The Dodd-Frank Act of 2010 was implemented in the wake of what many consider to be the worst US financial crisis since the Great Depression. The purpose of the Act is to implement financial regulatory processes that enforce transparency and accountability while providing for consumer protection. I'm joined today by Professor Eric Talley from the University of California at Berkeley. Dodd-Frank is over 2,000 pages long and requires 387 rules by 20 different regulators. It's incredibly complicated. What is Dodd-Frank all about?
I guess it's probably easier to answer the question about what it's not about. Dodd-Frank is undoubtedly the largest piece of financial and consumer regulation in our lifetimes, and probably for the lifetimes of some generations before. When compared to other very large pieces of legislation, such as the Sarbanes-Oxley Act in the early 2000s, Dodd-Frank dwarfs it immensely. It not only creates new regulatory entities, but it spreads federal regulation to areas where it had never existed before, areas stemming from systemic risk to consumer rights, to corporate governance, to securities regulation.
And at this point, what are the key issues that are preventing implementation in a timely manner?
Well, I think the key issues preventing implementation are a grab bag of a number of different things. One of them is pretty fierce resistance by entrenched interest in the banking industry to particular types of interventions, most notably the infamous Volcker Rule, which restricts the ability of banks to make certain types of trades on their proprietary books. In addition, just the vast complexity of many of the Act's provisions have made it very difficult to try to have a complete hearing of all the various vested interests in the Act's mandates. In addition, the new Consumer Bureau, which was created, wasn't even staffed until recently, and there was a fairly significant political pushback on potential nominees. At the end of the day, the president made a recess appointment to the position, and so a lot of the consumer protections, with a new agency with no head, was essentially unable to implement any of those provisions that it was going to be charged with doing. So, I think it's a combination of very, very standard meat and potatoes political backlash, a little bit of uncertainty aversion, not knowing exactly where we're going to be wading in this new omnibus form of legislation, and then just the large bureaucratic wheels of putting a new agency or set of agencies together.
You spoke of the Volcker Rule, which has been the subject of extensive lobbying. Another lesser-known provision that has made its way into the financial reform bill was a provision on conflicts minerals, banning the sourcing of minerals from the Congo. How did it make it in there?
That's kind of an interesting story, because it wouldn't necessarily be the type of thing that you would expect to go into a legislative endeavor dealing with systemic financial risk. The conflict minerals provision was actually a bill that had been floating around for a number of years before the financial crisis ever hit. That bill had gotten signed onto by a number of large organizations and corporations, largely as kind of a manifestation, I think, of corporate social responsibility in companies that sort of cared about the sourcing of conflict diamonds, in particular from the Congo. But it had kind of stalled in Congress, and at the moment that Dodd-Frank was being put together, the sponsor of the bill ended up taking a couple of provisions, injecting them into the bill, and it basically went through without debate. Now, this is a little bit bizarre, though this is undoubtedly a phenomenon that happens on a lot of very significant, widely scoped bills. They pick up a few extra provisions here and there that don't have obvious relevance to them, but that may be necessary to patch together the appropriate coalition to support the bill as a whole.
Well, it seems the SEC will have a big problem conducting a cost-benefit analysis on the conflicts minerals provision and the effect of the regulations, because they can't accurately pinpoint the cost to industry. What do you think the implications of this will be on the rule?
Well, the SEC has had a heavy going in earlier cases in which they've passed new rules. Proxy access was a rule passed last year by the SEC that would essentially give shareholders of publicly traded companies much greater power over who gets nominated to be on the boards of those companies. And the SEC last year ended up implementing a rule change that would give shareholders much more power. I think a lot of people don't realize that shareholders actually don't have that much power to nominate new new directors. That's something for the directors to do. That provision was challenged for conducting an inadequate cost-benefit analysis, and it was challenged ultimately successfully. And this is one of a number of different challenges that have ultimately been successful, in which the SEC has, tried to sort of make the case for why they believe that a particular rule change is worth the potential cost. But it's a very complex process. I think the conflicts minerals provision is one that actually even has much greater uncertainty associated with it, because quite frankly, a lot of the dynamics of this market are underground. We don't know much about how this market works, and so trying to measure how well this provision is going to work, or even kind of get a sense about how active these markets are, is an enterprise that's freighted with uncertainty.
The SEC has recently been criticised for its tepid enforcement strategy, particularly in relation to no-admission settlement agreements. Is the SEC's enforcement strategy effective?
Well, I think one can take kind of a glass half empty or glass half full approach. It's undoubtedly the case that certain defendants, particularly to regulatory actions that may also turn into criminal actions, will tend to insist on making a no-admission settlement. There are a lot of reasons why defendants will push for this, some of them having to do with insurance, some of them having to do with criminal liability, to the extent that those admissions or lack of admissions still give rise to compensation for shareholders. I guess some could claim that this is, in fact, still serving at least a broad number of the purposes of securities regulation. That said, I think that there are a lot of folks who believe that the very act of public shaming on some level of known and successfully prosecuted allegations of fraud or securities violations that's an important part of the deterrence puzzle. And so a no admission settlement has got maybe one of its arrows sort of taken out of its quiver, and I think some people would think that that was one of the most important parts of it. Now, the other thing to note is that the SEC in some domains has actually been quite active. So the SEC is more active than it's been in 20 years in insider trading prosecutions at the civil level, and in fact the Department of Justice has gotten into the act as well. And to the extent that people think that that's a potentially large problem in the publicly traded company setting, this is an area where we've seen a lot of activity over the last couple of years.
Now, Dodd-Frank requires substantial organizational reform of the SEC. Where are we with that?
Well, it requires organizational reform of the SEC as well as other federal regulators, and I think most of the provisions that the SEC has been trying to put in place are still essentially on the drawing board. There is a whole slew of them that are supposed to be implemented in middle of 2012. A number of those have been pushed back or are probably going to be pushed back even later. So, I think that there's a real sense that people aren't exactly sure where the dust is going to settle and when the dust is going to settle on reorganization of the SEC, ceding of some authority from one division to another. And I think that, in many respects, this is kind of a learn as we go process. So where is the smart money? I think probably the smart money is that we're likely to see more delays. How long those delays are, I guess, is still an open question.
And finally, what are the major battles left with respect to Dodd-Frank, and how do you see them playing out in the forthcoming presidential election?
Well, Volcker Rule still is a relatively large contention point. I guess the way that this is sort of playing out right now is that there is a set of proposed rules that have been finalized. They're supposed to go into effect in the middle of 2012. One of the things that has occurred during the process of the shaping of the Volcker Rule, during the notice and comment part of its passage, is that very large exceptions have been worked into it. Yes, banks aren't allowed to invest in hedge funds or certain types of derivatives, but they can engage in a practice known as market making, where they are essentially providing liquidity to the market in these in some of these close by products. They are able to loan to various entities they wouldn't otherwise be able to take an equity position in. And so I think a lot of people are sort of worried that either something like the Volcker rule is still going to be in play by the time we hit the election, or if it's already finalized, it'll be watered down so much that it's really not going to have much of an effect. There are a number of corporate governance provisions that are going to be interesting to see how they play out, and we are still sort of in the beginning process of trying to figure out how the new consumer division is going to be rolling out new regulations. It's kind of a dangerous and perilous time to start doing that right on the eve of an election, but that will be kind of an interesting dynamic to see how it plays out.
Thanks for your time, Eric.
Pleasure to be here.